Don't make anybody knock on the door.
Only volunteers get the fill. Empty promises is what they hear.
Don't knock the door.
No running water from year to year. Hearts that no one desire. That if there is a Messiah, someday he hear their whispered prayer. Covered always bare and scanty. 10 people in a one-bedroom shanty. What's the sell on the
Max. Testing. Is everything good in terms of song?
Yes, I'm checking. Max, are you hearing me?
Huh?
Can you hear me clearly?
Yes, I'm hearing you. Come to the screen.
Is that better?
That's a little better.
I'm not hearing you clearly.
You're not hearing me clearly?
Clearly? I heard you clearly.
Mothers just hold their head on ball. And them woman stronger than a wall. A big pusher iron she daughter. Son in jail for manslaughter. Too bad for him, be a name bad boys. No bail, that's the black man's choice. Shadow say cover tickets, hell. She little girl child belly start to swell. Some say life is a cycle. But don't draw, she no circle. Yeah, will it all end on it? Tell. Outside the siren keep howling. Inside your belly will growling. Police raid very often. Simpson measuring a coffin. One night in bed you're sleeping. Next night is a wave that you're keeping. So you're praying to win the lotto. Not to hear voices from the ghetto. From the ghetto, voices from the ghetto. We are not a forgotten people. Hear our with dented pride, they soldier on. Revolutions, faith, politicians born. And often their tragic story brings a journalist glory. No wonder they view the world with scorn. From since the day they're born, some call them rebels without a cause. These social victims of
Good evening, St. Vincent and the Grenadines. My name is Jomo Thomas. The program you're about to listen to is called The Voice. The feedback is coming from someplace. I'm not sure where. So we have a good program lined up for you tonight. We have Mr. Maxwell Holder. Maxwell Holder is an attorney. He's head of chambers at Frederick's Attorneys. And we have the lawyer politician, Mr. Luke Brown. Both of them would spend the next 2 hours with us talking about our Constitution, talking about the government's effort to change the Constitution and the Representation of the People's Act, and to speak to all of this in the context of democracy, democratic best practice, and all of the other important questions that you may have on your mind. But before we do this, I want to read my column for last week. It's called Self-Serving and Unwise. And it goes like this. The decision by the government to amend the Constitution and the Representation of the People's Act without public debate is, to say the least, self-serving and unwise. The act is not illegal, but constitutional tinkering and substantive change demands more than the listing on the order paper for next Tuesday's parliamentary session. It is particularly troubling since, according to the reports, the government intends to conduct all 3 readings and pass the law when Parliament meets. The government says that there's nothing wrong with the proposed change. It is simply to offer clarity on a matter of fundamental importance. There are several flaws in this approach. Chief among them is the fact that following the elections of last November, election petitions were filed in the High Court challenging the eligibility of then opposition leader Godwin Friday and Fitz Bramble, the East Kingstown parliamentarian. The petitions were premised on the notion that both men held dual citizenship, and in doing so had sworn allegiance to a foreign power, Canada, and therefore ran afoul of Section 26 of our Constitution, which prescribes such action. Dr. Friday and Mr. Bramble have long maintained that our Constitution makes clear that any Commonwealth citizen meeting the requisite residency requirement is allowed to offer themselves for election or nomination to high office. They maintain that since Canada is a Commonwealth country, the issue, as we say, is an open and shut case. So confident was Dr. Friday that on emerging from the first hearing of the election petition on March 3rd, when Justice Jomo Thomas set the hearing for July 28th to 30th, he described the challenge as frivolous distractions that took him away from the pressing task of national governance. Strange then, we'd say, that less than a month after such bombastic utterances, his administration hatches the legislative sleight of hand to take the matter away from the court's determination or to propose a constitutional spoon feeding as to how the court must interpret who is a foreign power or state. Is this a sign that the government is running scared? We think so, but unnecessarily so. Our Constitution is uniquely different from many of those gleefully cited by Dr. Gonzalez and his supporters. There are 3 branches of government: the executive, to administer the affairs of the state; the legislature, to make laws by which we are governed; and the judiciary, whose task is to interpret the laws. The issue as to what our Constitution says is preeminently a matter for the court. It is not for the government to attempt to show up its position, to change the law under the guise of bringing clarity, when the very law they are attempting to clarify is before the court for decision. The court must be allowed to do its work. It is uniquely positioned to bring finality to this very important matter. Another problem with the proposed amendment is that they smack of opportunism. If a government intends to tinker with an instrument as sacred as the Constitution, why not do something bold, meaningful, and progressive? Why not change the Constitution to read that any person born in St. Vincent and the Grenadines is eligible for election and or nomination to high office? There are thousands of Vincentians holding American citizenship who are locked out of our political process. Why accord more right to a Pakistani Taliban, an Australian racist, or an English greedhead, simply because they are from a Commonwealth country? Clearly, limiting the change to Commonwealth citizenship, many of whom have little or no connection to SVG, would leave us stuck with the colonial constitution granted by the British at independence in 1979. A further problem with the proposed amendment is its retroactive nature. Laws, to be truly meaningful, must be proactive and forward-looking, not stopgap and reactive. To give the legislation legislative effect is a thinly disguised ruse to offer an insurance policy to PM Friday and Fitz Bramble, whose elections are being challenged. Dr. Friday and Mr. Bramble seem seem to have taken the issue of Canadian citizenship to a level of a fetish. Both men, now in their 60s, are senior officials in our government. Both could usefully serve for another 10 years in Parliament. PM Friday is eligible for the best healthcare Vincentian taxpayers' money can buy, even after retirement. If social security benefits and healthcare are the basis for their clinging to Canadian citizenship, is that not a commentary on their commitment as senior government leaders to improving the general health and social security situation in our country? Something needs to be said about the rowdy chattering of the opposition. The challenge is an opportunistic gambit by Gonzalez and his clansmen. Dr. Friday contested and won elections 5 consecutive times before the challenge in the 2025 election. Fitzbramble's eligibility was questioned in his second outing. Both men were central advocates in the opposition's massive electoral victory. Brown, the ULP's East Kingston challenger, was whipped by 1,000 votes, while Friday's 6th victory was a no contest. The opposition claimed that now is better than never, but those making the claim have no moral authority to express outrage at the government's constitutional gambit. During his quarter century as prime minister, Gonzalez became notorious for violating the law. The ULP's approach to public administration is suspect at best and borders on illegality. The Public Administration Act essentially runs a horse and carriage through the Constitution. It fundamentally usurps the authority of the Public Service Commission regarding which public servant can be hired and or promoted. Then there's the Finance Administration Act, which grants the government authority to have an overdraft facility. The Gonzalez government routinely violated it by borrowing more than the law allowed. It also compounded the violation by turning a large portion of the overdraft into a government loan. The opposition leaders attempt to persuade us of the merit of the court is convincing evidence of a person practicing quackery and a similar confidence trick to obtain power, fame, and other advantages through pretense or deception. Following the 2015 petitions challenging Louis Straker and Montgomery Daniel, Gonzalez said, "Courthouse does not determine who represent you. I want to emphasize that. People who represent you are those whom people vote for in an election. And there will be other elections in St. Vincent and the Grenadines in which real flesh and blood people who are entitled under the law and constitution to vote will vote. That is our system. Judges do not decide who your representatives are." Now he's singing a different tune. Politics, narrow, partisan politics is ruining this nation. A refusal to be duped by either side of the political divide is the surest guarantor for our maturity and development as a people and nation. That was my take for last week. I don't know if any of you good gentlemen want to pick it apart. If not, I can try to pick your brains.
Jomo, good night. Jomo, good night.
Good night to you.
Good night to all the listeners of the program. It's not a matter of picking apart your column from last Friday at this moment. As you would appreciate, there are some things that you express in the column with which I would agree and some things with which I would disagree. I just wanted to put that there as a disclaimer. Having said that, I suppose that via your column you have provided something of an appropriate and relevant backdrop to the program tonight, considering the subject at hand and considering the fact that tomorrow is going to be a very interesting day in the history of St. Vincent and the Grenadines. Thank you for giving me the opportunity to come on the program tonight and I'm sure that you would appreciate the fact that I am here and I may be wearing several hats on the program
Well,
tonight. But
I did say politician and lawyer.
well, well, those are two of the hats, but very importantly, in connection with the issue at hand, I also wear the hat of petitioner in this
Yes,
case,
yes, yes.
and I think that that is perhaps more
Well, that
fun.
may be a good place to jump off. If you are a petitioner, well, not if you are the petitioner. Don't you think, Lou, that is a little more than passing strange that a man who ran in a constituency and has been convincingly beaten 4 times told the media last week that, look, I would love for this man to be declared ineligible so that I can serve after the people rejected you 4 times. Well,
Well,
5 times.
I will don't exaggerate the number of times, but in any case, as I'm sure that you'd appreciate, Jomo, there are a few things that are irrelevant for the purpose of the discussion that we're having today. One of the things that is irrelevant, which people have sought to bring into the discussion, is the extent of the victory of the current government at the polls. Another thing that is irrelevant is my own political history in the constituency. And a third thing that is irrelevant is the consideration of the number of votes or the margin of victory that may, based on just the
No,
surface
but
view.
that's a purely legalistic argument. I mean, I'm talking about the political reality on the ground. You have been whipped 4 times. You were badly beaten last time, and told the media, look,
I
throw this
didn't.
man out, and I'll immediately jump in.
Well, you being the careful man that you are would perhaps appreciate that I did not say that to the media. I said to the media in the course of an exchange that I would properly expect that in respect of in treating with the matter of the petition before the court, that we will play by the rules, and
Yes.
that we will play by the rules as they existed on election day. You'd appreciate that I didn't have anything to do with the making of the rules. You'd appreciate that I'm subject to the rules just like any other candidate that participated in those elections. And whatever the outcome of the rules, and I'm sure you'd appreciate too that the court is going to ultimately decide the outcome under the rules. I would abide by. I would abide by.
Yes. Okay.
Having said that, it could be the case, and you have said this yourself. You've said that the petition cases is not a slam dunk. You have said
Yes.
that you have said that even though you say it's not frivolous and that the impugned representatives have a case to answer. Yeah, and if it's not a slam dunk in terms of whether or not the court will rule that these gentlemen are disqualified, then there's certainly no slam dunk as to what the court. So there's no slam dunk about that. And even if the
Right.
court rules that they're disqualified, it's not straightforward that the court will prescribe a particular outcome, be it the outcome of a by-election or the outcome of a seat.
I thought your view was that once the court rules that these guys were disqualified, your view and the view of your leader is that once the court rules that they are disqualified, the persons who came second are the ones who would assume the seat.
Well, that is a possibility under the law, and that if I mean, and I know the law. If the
What is
judge,
what is the law you're referencing?
if the judge finds that certain
Which is the law
conditions,
you're referencing?
no, but the law, and I'm going to
Which law?
I'm going to elaborate if you would allow me to
Point us to the
elaborate.
law and then elaborate the
Well,
law.
I'll point you to the conditions first, which are established in the law. If the judge finds that some conditions are satisfied, like if the judge finds that there has been a wide circulation of the of notices of disqualification prior to the elections in terms that are clear and certain. The judge in those circumstances may rule that the person with the most votes outside of the individual that is disqualified might take the seat. And that is established in cases in our jurisdiction, including cases related to petitions that took place in Dominica and cases related
What does section 49 4 of our constitution say?
Section 49.2.
4.
Section 49.4 of our constitution, almost as if I anticipated your inquiry. 49.4, where the seat of a member of the House falls vacant otherwise than by reason of a dissolution of Parliament. It speaks about by-election, but
No. Read it so that people can hear it.
Well, you didn't ask me to read the.
Oh God! Well,
the entire...
I ask you what it says.
Well, first of all, you didn't ask me, I am at liberty.
No, this is precious radio time, yeah. I don't.
No problem. And precious radio time doesn't mean that you would dictate how I respond to a question that you asked. If you want me to,
I ask you what it says. What does section 49.4 say? I expect you to read it and tell us what it says.
Well, you could be in a position to read it, but in as much as I have it here at hand, first of all, it's not relevant to this matter. But in as much as I have it here at hand.
Okay, if you say it's not relevant, let's not dwell on it. Let's not dwell on it. It's not relevant. It's not relevant. Maxwell, I want to bring you in because you wrote a piece a few weeks ago called Dual Citizenship and Parliament, What the Drafters Really Intend. What do you think, sir, the drafters intended? Particularly as it relates to the issue of Commonwealth citizens.
Thank you, Jomo. Thank you for having me. Good evening, everyone, and good afternoon to my colleague. Now, Jomo, when I spoke about what the drafters really intended in terms of our Constitution, I think what we need to appreciate is really the historic context of the Constitution. Because as our Constitution is, and there is a presumption against ambiguity. What it is
a presumption against what, sorry?
Ambiguity. So what is important is that we have to have an appreciation of the historic context of the Constitution. So I remember Renwick Rose in a piece which he entitled Constitutional Review, The Experience of St. Vincent and the Grenadines, where he said that the Duke of something or the other came down and supposedly gave us this independence constitution. And that is the law giving effect to the independence of St. Vincent and the Grenadines, which was through an act of the UK Parliament. Now, the design, Jomo.
Maxwell, come into the frame.
Oh.
You are
I'm not hearing you all the time.
Yeah, much better.
Right. The constitutional design at independence was really driven by Caribbean political elites and the government and the London-based civil servants at the Colonial Office, and which is now called the Foreign Commonwealth Office. And they really were in charge of drafting our Constitution. And when you see the term Commonwealth being used throughout the Constitution, to my mind, it should mean something. And the very nature of Section 25 says a lot. And of course, you have to read, as my learned friend.
What does Section 25 say for persons
Section
listening?
20, right. So Section 25 of the Constitution provides, subject to the provision of Section 26 of the Constitution. So of course, you have to qualify under Section 26. We'll get to that. A person shall be qualified to be elected as a representative if and shall not be qualified unless he is a Commonwealth citizen of the age of 21 years or upwards, has resided in St. Vincent and the Grenadines for a period of 12 years, or the
12
date,
months. 12 months.
sorry, 12 months, yes, immediately before the date of his nomination or election, and is domicile and resident in St. Vincent and the Grenadines, is able to speak aided by blindness or physical cause to read the English language, the degree of proficiency sufficient to enable him to take active part in proceedings of the court. Now, the Constitution does not limit eligibility to citizens of St. Vincent. So, because there is a qualifying section, we have to look at Section 20 also. And this is where no person shall be qualified to be elected or appointed as a representative or senator if he is by virtue of his own act under acknowledgement or allegiance, obedience, or adherence. And of course, we are aware that a foreign power or state is not defined presently. Now, the drafters could have followed a different approach in drafting. For example, they could have used the St. Kitts model, which restricts Parliament to its own citizens. So this Constitution of St. Kitts, and of course, I believe that my friend will embrace heavily the decision of the AG and Denzel Douglas from the Court of Appeal. But 27, which is the corresponding section in St. Kitts, provides that subject to Section 28, a person shall be qualified to be elected or appointed as a member of the National Assembly and shall not be so qualified unless he is a citizen of 21 years or upwards, and he or she or one of his or her parents was born in St. Christopher Nevis, and he or she is domiciled there at the date of his or her nomination for election, his or her appointment, as the case may be. And of course, it has a qualifying section, which is Section 28, which provides a person shall not be qualified to be elected or appointed as a member if he or she is by virtue of his own act under any acknowledgement or allegiance, obedience, or adherence to a foreign power or state. Now, it is quite evident that the Constitution of St. Kitts does not permit unfettered access of the membership to the National Assembly. So there is a qualification there that you must either be a citizen or your parents were born in St. Kitts and Nevis. Now, I'm not sure if I should stop here and give room for the discussion before.
Well, okay. But why did you point us to the Constitution of St. Kitts?
Right. So what is important, Jomo, is that a lot has been said about the decision of the Court of Appeal of the Eastern Caribbean Court of Appeal.
You're being asked to move your hand from your mouth. Sometimes you
Sorry.
become inaudible.
In Denzel Douglas' case. And I've seen a lot of articles making reference to that decision. But it's very, very important to understand the background in that case, and it's very important to understand the context of that case. And the Court of Appeal, at paragraph 27, if my memory serves me correctly, in that decision, spoke about the purpose of parliamentary disqualification. And what was important in that particular paragraph is the Chief Justice Prior at the time relied on a decision out of Australia of Justice Brennan in Sykes and Clearly. And she said, Section 41 whole purpose when persons with foreign loyalty or obligations from being members of the Australian Parliament. That section was designed to ensure that members of the parliament did not have split allegiance and were not, as far as possible, subject to an improper influence from foreign government. Now, the question is simple. Why did the drafters of St. Vincent and the Grenadines Constitution choose a different approach? And it must be that at the time of independence, the vision, and I think I stated this in my piece, the vision was a shared common across the region and the Commonwealth territories will participate in others' democratic institution. So it appears to my mind that the intention is clear. The pool of eligible candidates should be wide and inclusive and connected to the Commonwealth. And that is where I would stick a pin, and then I will go further after I hear my life.
Right. Look, you, a number of other people, I'm not just here talking about political people, because I know persons who are not locked into the ULP in any way, who hold a view similar to you and the ULP leadership that says the issue of allegiance to a foreign power is fundamental. And therefore, the fatal flaw in the Dr. Friday, Mr. Bramble's case is that that issue is open and shut, because at the first hearing of the matter at the court, they admitted to the court that they are Canadian citizens. Is that the key and central issue for you? Luke, you heard me?
Yeah, sorry, I'm on mute now. I say there are a few things I'd like to say in response. That first of all, I'd like to address some of the things that Maxron said in his comments a while ago. He said that the drafters of our constitution were in Commonwealth offices, and therefore there could be by some reasoning a sense that they wanted to leave the door open to Commonwealth participation in the elections, and that is why you have that possibility in our constitution.
But isn't that clear? Isn't that clear from our constitution?
Well, I want to make the point that the same type of people drafted all the constitutions basically in the English-speaking Caribbean. So
yes.
the question of them wanting to exert that type of influence in how our democracy unfolded is neither here nor there. And then you also,
why do you think some of the constitutions say that you have to be a citizen to run, and others don't say that?
Well, it's neither here nor there why this is so. I just accept that this is so. So one constitution could restrict citizenship to or participation to citizens of the particular country, and another constitution could make it a bit wider than that.
And you don't think there's any relevance to any of that?
No, there's no relevance to, if you try, there's no relevance to the matters which are addressed in section 26 of the Constitution as distinct from the matter of section 25, and I'll say why in that.
Yes, please.
On that point. But even before saying why, the brother Maxron also spoke about foreign power or state not being defined presently, and that is not true. It may not have been spelled out in the Constitution itself, but in cases in our jurisdiction, there has been a definition of foreign power or state, and in those cases, foreign power.
Tell us about the cases that.
Well, he cited the case of Dr. Denzel Douglas in St. Kitts and Nevis, and in that case, there is a clear definition of in that case, in the appeal case, and in the case in the High Court which preceded it, there is a clear definition of what is a foreign power or state. And a foreign power or state was defined in such a way that made it clear that Dominica was a foreign power or state with respect to St. Kitts and Nevis, despite the fact that they are in the same OECS, in the same CARICOM, and in the same Commonwealth. In fact, the court took great pains to establish that point, that there is a difference between these countries in relation to the consideration of a foreign power or state, despite the fact of their common membership in the Eastern Caribbean, in CARICOM, and in the Commonwealth. That was explicitly pointed out in the case. And if you might say that there was some ambiguity on that matter before the advent of 2020, I believe that 2020 certainly cleared that up beyond a shadow of a doubt. And, you know,
before you move on, I want to ask you this question, because I have seen where, I can't remember seeing you citing the case, but I've seen where people who support the view as you just articulated cited the Valls case. Do you think the Valls case support your view?
I'm not citing the Valls case. The Valls case
No,
is
I'm
outside.
asking you if you think the Valls case supports your view.
I'm saying that the Valls case is not binding on our jurisdiction, and I'm not giving it consideration for the purpose of this discussion.
Okay. I want to read a paragraph for you from the Valls case.
But
so that
you may do that, and you may also qualify.
Look, it's for the audience. It's not directly. This is not between me and you.
I know, but I'm saying just before you do that, I'll qualify it by saying the Valls case is outside of our jurisdiction and is not binding. And the comment that you are going to read from the Valls case as well, but I presume that you're going to read, you might well read something else, is a comment which was made as a part of the obiter in that case. So just to preface it with all of that, you may read your extract from the Valls case.
Okay, I want to read paragraph 35 of the Valls case, where it says, the framers of the Constitution clearly intended that Jamaicans who by their own act sought and received non-Commonwealth citizenship, or having not so sought it, nevertheless voluntarily acknowledge allegiance to such countries, should not sit in the House of Representatives. It does not matter that they were born in Jamaica. It is a notorious fact that over the years, many Jamaicans have acquired foreign citizenship, and many others are constantly in the process of seeking such status. If they choose a distant, autocratic, unfriendly Commonwealth country for their citizenship status, they can still serve in the House of Representatives. If, however, they choose to acquire such status as in the United States of America, they are friendly and accommodating neighbor to the north, they are disqualified. That may seem an oddity, given the fact that many Jamaicans seek United States citizenship and are more likely to be accommodated in that country compared with the level of accommodation they would receive in many Commonwealth countries. However, that is the Constitution. So the judge in that case was making the point that by virtue of the fact, it doesn't matter where a Jamaican, and the sections are the same in our Constitution and in the Jamaican Constitution, says that irrespective of where the Jamaican resides and become a citizen, once it's a Commonwealth country, it doesn't matter how autocratic or repressive or anything, that person would still be allowed the opportunity, the privilege, the right, even the duty, one might say, to put themselves up and to be elected or nominated to high office. And I take it that you would rubbish that section.
Well, it's not a matter of rubbishing it. It's a matter of putting it in its right context. And in order to
help us to put it in context.
And well, I sought to do that even before you read the extract.
By saying it's arbiter. By saying it's arbiter.
By saying it's outside. It's outside of the Eastern Caribbean jurisdiction, and it is an
outside
arbiter.
The Eastern Caribbean or the OECS?
What's the difference? The OECS. It's outside of the jurisdiction of the Eastern Caribbean Supreme Court, and it is an arbiter comment, We are guided by the comments which are made, which are binding, which are made in our jurisdiction, and which form part of the ratio of the case. So
Right.
that puts that vase extract, I think, in its proper context. And Jomo, ultimately the court will decide.
Yes, but hold on a second, Luke. Mr. Gray and others like you, please stop making these comments. This is a mature conversation about serious issues. I'm not sure what you all are trying to do. What do you think you get from the kind of silly comments that you make? Continue, Luke.
Yeah, and like I was saying, Jomo, I mean, the court will decide, and I would abide
No,
by
I am with you on that point. I am with you on that point.
and I would abide by the decision of the court. In this matter, I exercised my constitutional right, according to Section 36 of the Constitution, to challenge the outcome of the election. And having done that, it is also my right under the Constitution to have a free and fair trial in relation to the challenge that I mounted. And what the government is seeking to do tomorrow touches and concerns my ability to have a fair trial. The outcome of the court is not in my hands. The outcome of the court is in the hands of the judges. I am prepared to abide by the decision of the court, but this matter, in a very serious and fundamental way, transcends. I believe that there are good arguments in relation to the petition for me and my co-petitioner, Carlos Williams, but I am prepared to set that aside for now, because I believe that this matter transcends the petition cases themselves and strikes at the heart, one, of my ability to get a fair trial, and also on the independence of the judiciary.
Yeah, Max wants to come in.
Jomo, if I may, I'm trying to if my friend would answer, how would he interpret section, I think it is section 29. How would he interpret section 29 of the Constitution, 29.3?
Section 29. It's a pretty long. What is it? It's a pretty
section
long
20.
section.
It speaks of the Constitution.
29.1 are you talking about? Because I'm saying that's 20.
Member shall also vacate his seat if in the House if he ceases to be a Commonwealth citizen. How would my learned friend interpret that particular section?
Oh, section 3B.
Yes.
Well,
so let's. Well, before you do that, let's. Maxwell is asking Luke to look at section 29.3b, and section 29.3b, section 29.3 says, a member shall also vacate his seat in the House if he is absent from the sitting of the House for such period and in such circumstances as may be prescribed in the rules of procedure of the House. And B says, if he ceases to be a Commonwealth citizen.
Okay, guys, this is really very straightforward. First of all, B, it gets back to the requirements for qualification to be a candidate. B deals with if he ceases to be a Commonwealth citizen, because you have to be a Commonwealth citizen to run. And I would like to make the point that Vincentians are Commonwealth citizens as well. We are a subset of Commonwealth citizens. But if you go on to C, you see that it talks about subject to the provisions of section 4 of the section, if any other circumstances arise that, if he were not a member, would cause him to be disqualified to be elected or appointed as such by virtue of subsection 1 of section 26 of the Constitution. So it is basically covering all matters. If you are no longer a Commonwealth citizen, and if something arises that causes you to fall afoul of section 26.1 of the Constitution.
Right, but if the Constitution says, and Maxwell, I commend you for that. If the Constitution says that a member shall also vacate his seat in the House if he ceases to be a Commonwealth citizen. What else do you think in Section 26 would cause, if he remains a Commonwealth citizen, what would cause him to lose his seat in the House?
If he becomes a minister of religion, then he will cease to be a member of the House. If he becomes a judge, then he will cease to be a member of the House. If he becomes certified to be insane, then he will cease to be a member of the House. If he becomes bankrupt, if he enters into a contract with the government, and if he becomes, by virtue of his own act, under an acknowledgement of allegiance to a foreign power or state.
Right. So I want to continue my thought here, Jomo. So let's look at it this way. So if the position,
But hold on, Maxron. Before you comment, I want to ask: do you think, Lou, that constitutions are generally restrictive or permissive?
Well, I'm not sure what you're asking, to be honest. I don't know if you
Not
mind
sure.
being clearer.
Do you think constitutions tend to give more rights to citizens, or they restrict their rights? As
Well,
a theoretical principle, as a theory of
I think that
constitution rulemaking.
I don't think that I could respond in those
Okay,
terms.
okay, that's fine. Maxwell,
A
continue.
constitution, what I would say is that a constitution is meant to define the rights of
Okay, all right.
citizens of a country.
Okay,
right,
Maxwell, please continue.
right. So where I was starting from here. So if we have to interpret section 26, right, that speaks of or allegiance by virtue. So I believe my friend is saying that if you decide that you are going to apply for citizenship, let's say in Nigeria, you are disqualified 26, right?
I'm saying that, and I want to use the precise language of the law. If you, by virtue of your own act, become under an acknowledgement of allegiance to a foreign power or state, then you become disqualified from being a
Right.
candidate in elections.
Right. So then, if someone is born, let's say in Nigeria, they would qualify under section 26, right? As it presently is.
Well, I'm supposing you're making a statement. I'd like you to complete your
No, I was
statement.
I was taking it step by step to try and
No,
understand your position. So you would agree someone is
I,
was born in Nigeria and they
I,
are 21
I
years.
would agree. I would agree if somebody who is born in Nigeria does not fall afoul of any of the provisions of Section 26, and in particular Section 26(1), then they will be able to participate in our elections.
Right. So relying on your authority on Denzel Douglas, that you strongly embrace, then that person born in Nigeria would not be by their own act because it would be by operation of law, right? So then you would agree that it is not a reasonable, it is a reasonable probability and not a fantastic possibility that a medical student from Nigeria that they've been living here for 2-3 years, they can become prime minister. But let's say Jomo, who has a British passport, cannot even be a senator. That is a reasonable probability, right?
Well, we would assess all cases assess all scenarios on a case by case basis. And I am in this case not interested in hypothetical scenarios. I'm interested in the scenario that I presented to the court as a petitioner.
Very
So,
well.
so Lou, So your argument or the argument of your party is hinged solely on Section 26, and for you, the other sections are of no moment.
Well, I'm not. I've never said that. The entire Constitution is appropriate, and we consider the Constitution as a whole, and aspects of it which are relevant to this case will apply to this case. And Jomo, you cast it in the way of my argument and the argument of my party, but
Or other people who I take that back. Because I did say earlier there are other people besides you and the members of your party who hold a view that both Dr. Friday, PM Friday, and Mr. Bramber would be ineligible.
yes, there are the persons who hold the view that they will be
Yes. So
ineligible.
I take that back.
So yeah, I mean, we look at it, but I was broadening the canvas because, like I say, and like you said, Jomo, the matter of the petition case is not necessarily a slam dunk, and the court will determine that. I am very happy for the court to determine that according to the rules which existed on election day.
Maxwell, I'm sorry, Luke, I thought you were done.
No, I'm saying I'm very happy to abide by the rules
Yes.
as they existed on election day. But we are going into a different arena here with the constitutional amendments.
Yes, I want to take Macron there. I want to take Macron there because you commented on that already. Macron, how do you come down on the proposed amendment, which would be heard tomorrow in Parliament? What's your own views on that?
Well, Jomo, to my mind, as you said in your article, there is nothing illegal about it. Also, everyone has their right to use the law as they see fit. My friend has used the law in challenging the elections, the qualifications of two candidates, and the other side has basically done the same. They are using the law. Now, there is nothing in section, I think, 38, if my memory serves me correctly, that would render this illegal. In the Constitution, there are provisions on amendments, and throughout the Caribbean, there are what we call deep level entrenchment, low level entrenchment. We have a provision for two-thirds majority in the Parliament. Now, if that is open to the other side, then by all means, they have the right to exercise that right, just as my friend has exercised his right in challenging the results, as I said.
So, Macron, hold up. So, what about Luke wrote a piece in which he premised the argument on the issue of fairness. He said this is an issue of fundamental fairness, and the proposed amendment denies that fundamental fairness that allows for a free and fair trial. You don't say anything unfair about the proposed amendment.
Well, Jomo, if you have to look at it that way, then sure, you would see that it is unfair, but as I said, not illegal.
Right. Okay. But if it's unfair, not illegal, I am of the view, and both of you can say, or other people who are listening can say, I think that the court, which is clothed in wide discretion, has the discretion, and I am feeling it will be exercised in this matter, to disregard this amendment that the government is proposing to use. Do you think that there's any precedent for disregarding any such change, particularly in a context where a matter is live before the court?
Well, The the proposed amendments, when you look at them, I think it's supposed to it's supposed to act retroactively.
Yes.
The tradition where the traditional where there is something illegal, for example, in criminal law, you cannot impose retroactive law in criminal law. But where this is concerned, the court has a wide discretion, yes. But at the same time, on the legislations, the rules of the legislature, what happens is that if there is something that the legislature did legal, then that is open to being challenged under the Constitution if it violates provisions of the Constitution.
Right. What about, based on what the government is trying to do and may well do tomorrow, do you think that it would be wise for people like Luke and others to make a challenge, a constitutional challenge to what they attempted to do on the ground? That, look, this thing is ultra virus the Constitution.
Well, Jomo, they would have to fit that under one of the fundamental rights in Chapter 1 and convince the court that it is in breach of one of these rights, because that is what happens when there's a constitutional challenge.
Well, Luke was pointing to free and fair trial.
Exactly. Under Section 8 of the Constitution has a fundamental right.
Luke is very much entitled to doing that, and we'll see how the court treats with that.
Well, I mean, it's not a matter of how the...
As I said, Jomo, everybody is using their right as guaranteed under the Constitution, and I would encourage.
I don't think it's quite as straightforward as that. And I mean, in matters of political and legal strategy and things for ventilation in a forum such as this. But it just suffice it to say, Jomo did use the word that did say that the actions are not illegal, but they're not right. I don't remember the precise formulation. But the actions could really well and truly be illegal. And we are concerned here about the retroactive nature of it. I mean, it's all well and good if the men don't decide that their Canadian passport is the next closest thing to God and they don't want to give it up, then fine. They want to change the law so that they could run in the future without ever having to give up that passport. I mean, it would have been useful for them to think beyond their own nose, to look at possible amendments to broaden the possible participation to the large cohort of intentions, which, for instance, are also Americans, but they didn't worry about that. But if they want to change the law for the future, that's all well and good. We might have a difference of opinion about it. You know, we might think that this is as a result of them having to face a challenge. This is about their self-preservation. We might still think it is a matter of power, but it would not have been unfair. And if a law is unfair, then that law is illegal. If a law is unfair, the law is unconstitutional. If a law is unfair, the law is ultra-virus.
Let me ask this question. Because it has loomed large since this information came out last week that there's this proposed amendment. Winston Young is saying, I think the government is doing a wonderful thing to bring clarity to the matter. Now, is that the court's role to clarify the law?
It is the court's role to
clarify. No. I'm sorry. Is it the legislature's role to clarify the law?
It's not. You were putting it the right way. The exclusive right to interpret and clarify laws rests with the court.
Maxron?
Yes. There's a clear separation of powers. The
Right.
legislature.
So, 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 so
So if
the
you are conceding, Max Run, that as I said in my column, there are three branches of government. The legislature makes the laws. The judiciary interprets the laws. We have a matter that is intending to explain what can Commonwealth persons do, and do Commonwealth persons swear allegiance to a foreign power? Is it for the court to say, or is it for the legislature to say?
Jomo, the question was framed. Um, can you frame it, because it would really determine my
Well, frame the question the way you want to answer it and then answer.
because is that the duty of the court is to interpret the law,
Yes.
and the legislature is to make
To
law,
make the law.
right?
But the law is already made, and there's a case challenging a particular thing in the law.
Right. The legislature is also the legislature is in their right, because there's a clear separation. The legislature is doing what they're supposed to be doing, legislating, and the court is still seized with the court case.
Right.
That
the legislature has to legislate within its lawful authority.
yes,
They can't do anything they want.
Well, let me.
Notwithstanding whatever your mandate, you don't have a mandate to do anything that you want, and that is the
Let me ask
issue
this
at hand.
question. Let me ask this question. You know, in the United States, right? And I know it's different jurisdictions, but I want to bring it just for clarity. The court. Let's take the privacy laws in the United States. Classic example: Roe v. Wade. The court has ruled. It overturned Roe v. Wade and thrown to the states who can have an abortion, right? Once the court has ruled, it is possible that the legislature, the Congress in the United States, can come and say, pass a law with overwhelming majority, veto busting majority, that says, for us, for this legislature, for this country, a woman has exclusive right to determine how all kind of privacy issues, including up to whether she wants to give birth to a child or not. So the court decides, and then the legislature comes back and says, this is what the situation is. Don't you think that's what we should follow in this case? I mean, such a rulemaking as they do in the United States, rather than to say we are coming to a matters before the court and we are trying to tell the court, look, here's the answer to the question that the petitioners are bringing. Yeah. That seems highly improper to me, Maxwell.
of course, that is always the preferred approach. There are always ambiguity in the law. We are taught that there are rules of statutory interpretation, and although laws are drafted by skilled draftsmen, there are ambiguities, and that is for the role of the court. And what the court does is that the court would engage tools of statutory interpretation to find what was the parliamentary intent, what was the legislative intent. So of course that is always the best practice, Jomo. But again, it goes back to saying, at present, the judiciary is doing its work, the legislature is doing its work.
I mean, it's not it comes to the point where really it's not a matter of saying that it is best practice for us to take this approach versus that approach. This is a discussion that is much more serious than that. This is not a matter of what is best practice. This is a matter of what is lawful and what is unlawful. And
so you think it's a close and shut case?
I'm not here to pronounce on what is a close and shut case. I would
Well,
present
you just said it's a case of what is lawful.
it is a case of what is lawful and what is unlawful, and I may have a view on it, but whatever my view on it, naturally it will be determined in the court,
Right.
And
But you would agree.
Just to make this point as well, we have been talking quite a lot about the need to clarify the law. That has been bandied about. This is an exercise about clarifying the law. But who says that the law isn't clear? Who says that the law needs to be clarified?
Well, the fact that we
hold on. So you think all of this noise that you are making, isn't it evidence that and when I say you, I'm only talking about, when I say you, I mean the collective you. Yeah. Isn't that a sign that there's something that needs to be decided in the law?
Well, Jomo, from my vantage point, based on my own knowledge of the facts and the law, I don't believe that there is something to be clarified, because I believe that the Court of Appeal and the High Court in our jurisdiction, these two courts, they have already established what is a foreign power or state. So on that
point, you don't think there's any difference at all between the whole notion of who can contest in St. Kitts and Antigua and Jamaica? You don't think there's a peculiarity about our constitution that needs to be addressed and decided?
I don't think the fact, just to answer the question in a straightforward way, I don't think the fact that the pool of candidates in St. Vincent and the Grenadines is open to Commonwealth citizens, whereas in St. Kitts and Nevis, it is restricted to citizens of St. Kitts and Nevis only. I don't think that has any bearing, and the court, in my view, has...
You don't think so?
I don't think that has any bearing on what is the definition of a foreign power or state. And, in a previous...
What about what the Constitution says on who is an alien? You think that has anything to do with decided Section 26?
No. And these precise issues, they were addressed comprehensively in the course of judgments in our jurisdiction, and included in the Denzel Douglas appeal judgment. And moreover,
what did the court say for persons who didn't read that decision?
Well, I don't have the decision here with me, Jomo, so I could provide you with the specific quotation.
No, not me. It's not me. I read the case. I read the case.
Well, fine. I don't have the judgment here with me, but it is addressed there. And secondly, so I believe so that matter has been treated, in the law. So I don't think there is any real need for clarity. I mean, but having said all of that, we subject ourselves to the authority of the court. And Maxwell was making a point earlier, saying, well, this is a case of me or the petitioners exercising their rights under the law to challenge elections, and a case where the legislature is using the law to forestall or circumvent that challenge. But I think it goes beyond that. What the legislature is seeking to do is to change the legal meaning of a word in the middle of a case that depends precisely on the legal meaning of that word. That's a very different thing, and that is...
Tell us again. What is the legal meaning of the word that the legislature is trying to change?
The legislature is trying to change the legal meaning of foreign power or state, and
it's doing that by doing what?
It's doing that by bringing the constitutional amendment bill, in which it is purporting to insert...
By doing what? There are a lot of people who may be listening, Luke.
Okay, it's doing that by seeking to insert retroactively a definition of foreign power or state in our constitution.
And what is that definition it's offering?
What does that, sorry?
What is the definition that the legislature is trying to offer?
Well, they're trying now to say that that no Commonwealth country is a foreign power or state for all intents and purposes.
Right. And are you saying that the Constitution says that a Commonwealth country is a foreign power. Our constitution says that.
I am saying that the interpretation of our constitution by the courts is consistent. The courts have interpreted foreign power or state as cited in our constitution in a particular way, and therefore that is the definition of foreign power or state for the purposes of the constitution. And
Right.
I'd like to highlight as well that there are a couple other places where in our constitution where there's a reference to foreign power or state, in which it is very plainly obvious that these references were to any country that is not St. Vincent and the Grenadines. Any country,
Point us to those.
for instance, in I think it is section 17 of the Constitution, 17.1, the Governor General may, by proclamation which shall be published in the official gazette, declare that a state of emergency exists for the purposes of this chapter. Section 2, every declaration of emergency shall lapse in the case of a declaration made when Parliament is sitting at the expiration of a period of 7 days, beginning at the date of publication of the declaration. In any other case, I'm trying to actually get to the point where there is the reference to the foreign power here. I wanted to lose that.
It's 17.2a that a public
17.
emergency has arisen as a result of the imminence of a state of war between St. Vincent and a foreign state.
2A, 17 2A.
Yes.
No, I don't see it in 2A.
17.2a says a proclamation under this section shall not
No, no.
be effective.
17 2A says here, in a case of a declaration made when Parliament is sitting at the expiration of a period of not less than 7 days, and
Are you reading the St. Vincent Constitution?
Yeah, of course. I'm not seeing
Because
that.
Maxwell, the St. Vincent Constitution says a public emergency has arisen as a result of the imminence of a state of war between St. Vincent and a foreign state.
Okay, fine. For some reason, I'm not picking it up at 17 to A.
Maxwell, what's the 17.2a in your Constitution say?
17.2a, Jomo.
Yes.
17, the declaration of emergency, and it on my copy.
It begins a proclamation under this section.
A proclamation under this section shall not be effective unless it contains a declaration that the Governor General is satisfied that a public emergency and as a result of the imminence of a state of war between St. Vincent and a foreign state.
Right. I thought that's what. Luke, so maybe something else you want to point us to what you were thinking about then.
So in 17, you have the reference to a foreign power, which clearly means any country other than St. Vincent and the Grenadines.
Also,
and I think there's a similar reference.
On what basis do you conclude that it means any country that is not St. Vincent and the Grenadines?
Well, on the basis of common sense.
Oh, I see.
And I just use that really as additional material for the purpose of discussion. But in relation to the cases, really the reliance is on the definitions which have been provided in the law in our jurisdiction before this date.
Jomo, if I may, can you hear me?
Yes, we're hearing you clearly.
If my memory serves me correctly, and we have to look at, for example, the Constitution of Jamaica, Section 40. But unlike, which is very much paramateria with what is in St. Vincent's Constitution, Section 40, subsection 2, and it provides no person shall be qualified or be appointed as a senator or elected member of the House of Representatives, who by virtue of his own act under acknowledgement or allegiance, obedience, or adherence our state. And Section 12, unlike ours, Section 12 defines a foreign country, which means country other than the Republic of Ireland, that is not part of the Commonwealth. And basically, what came out from the 1962 Constitution of Jamaica was a replica of what was found in St. Vincent. Now, of course, they didn't find a section. We didn't have a section 12 in ours that defined foreign country. So therefore, in a situation like that, and as I was saying earlier, when the court is interpreting these provisions, they look to the Constitution itself to try and find what the intention was of the frame.
Right.
And as you know, the Constitution is what we call sui generis. It's a living instrument and it calls for an interpretation of their own and suitable to their character, and are interpreted generously, purposively, with a view of avoiding tabulated legalism.
Mm.
The Constitution should not be construed in a narrow or a legalistic way. It should be interpreted broadly. And I think it was Lord Keith
Well,
who
I was
said
trying to make that point earlier. My friend Luke didn't agree with me.
to give effect to the spirit of the Constitution. And of course, again, in understanding sections 25 and 26, you have to give effect to the spirit of the Constitution and you have to look at it as a living and breathing instrument. And what the Constitution is saying to you, that is how you get the intention of the framers when you speak about sections 26, sections 25 and 26. So when you examine the language used and object and purpose of the relevant provisions, it speaks throughout. It keeps mentioning about Commonwealth, 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 Commonwealth. It means something, and it is speaking to us, and we must. Now, I want to speak about a legal absurdity. A few moments ago, I asked my learned friend, and he said that he is not interested um, in scenarios. Where I said to him basically that if we have to go with this interpretation, what will happen is that a Nigerian medical student would be able to qualify to be prime minister, and Jomo, the Vincentian born with a British passport, wouldn't be able to qualify to even be a senator, but yet we have a Nigerian prime minister. Now, the Privy Council has reminded us time and time again of the presumption against absurdity, and it is well established in law. And it is without question a method of purposive statutory construction. And we should always seek to avoid absurdity or unlikely results. Well established that a court would lean against the construction of legislation which produces absurd or unworthy results. And if there is an available construction which does not do so, the court would lean in that favor. Now, absolutely, the interpretation that my friend is proposing is going to lead to an absurd result, whether he admits it or not. Whether he is saying that it is a scenario, that is an absurd result. And again,
Um,
Well, before you go on, why don't we let
mhm,
why don't we let Luke respond to that point?
well, first of all, I do not agree that this situation leads to any absurd results, and the same
Oh, so you
logic.
just hold on. So you
Mm.
think that the example he gave is not absurd?
I don't think that it is absurd
Okay.
for the constitution to
Niger
operate in this way.
the
And let me
Nigerian.
and I think it's very important for us to understand really the reason why there are some restrictions on candidates, and these restrictions apply to Vincentians in the same way that they apply to other persons. I mean, it might be very clear to us why we would have a restriction, for instance, on judges running in elections. So a Vincentian who is a judge cannot participate in our elections. There's
You told us that. You told us that already, though. So you don't need to
right.
go back.
No, but I'm saying, but I didn't get into the matter of the reasons why this might be the case, and I would
What's the
like
reason?
to. Well, I mean, I suppose the reasons have to do with matters of separation of powers, and
I thought so.
there's a reason why persons who are under an acknowledgement of allegiance by virtue of their own act to a foreign power or state are restricted from being in our parliament. And that reason, as set down in the law itself, is to prevent the possibility of their prosecution overseas for acts that they do in St. Vincent and the Grenadines that might have an adverse impact or that might be illegal somewhere else. It is put this way to be very precise in a judgment. There is good authority.
Where is it?
This is in the. This is a quotation by. I think it's either in the Denzel Douglas Appeal Act appeal case judgment or in the appeal case in the judgment related to Roosevelt, Skerritt, and Dominica. There is good authority for the possibility of legitimate prosecution for acts done by someone in this condition which are against the interests of that foreign power or state. This is the basis for the state of the law to prevent, quite apart from the matter of divided loyalties, it is a matter of insulating our leaders from prosecution abroad for actions they take here. So this is not
But
a willy-nilly provision.
but can we appreciate that a person does not have to be a citizen of St. Vincent and the Grenadines to run in elections? And of course, your result, your scenario, the result would be the same. It would be the same thing. So
What
your
do you mean? Be the same thing? How? What do you mean? If you
what
are
I,
not under, if you are not under by virtue of your own act and,
wonderful.
and
So
an allegiance to a foreign power or state, then
right.
you are not open to the prosecution that we're talking about.
So we are bringing in this provision, and
So
now we are back.
any Commonwealth person would not be open to that same thing.
Well, if any Commonwealth person who is not by
Who
virtue,
is now an elected representative or even the Prime Minister of St. Vincent, wouldn't they be open to the same thing?
well, so long as they are not by virtue of their own act under an allegiance to a foreign power or state, they will not be open to the same thing.
But they would still be on the according to the rules of international law, they would still very be subject to that state under the rules of nationality under international law.
They will not be subject to prosecution for their actions as a representative in St. Vincent and the Grenadines. That is the law.
What kind of actions you envision? You mean like criminal actions and so on?
Well, it's not for me to contemplate the types of
No,
actions.
but don't you think that any such action for which you might come under some jurisdiction would have to be some kind of criminal activity? I mean, the Americans snatched President Maduro and they're trying him under their law.
Well, that is illegal, Jomo.
I think what
that is illegal, Jomo, and that precisely helps to drive home my point. The illegality, if Maduro was under allegiance to America, they would not have to conduct an illegal operation to get him.
I think what my friend is alluding to is the provisions under the Vienna Convention on Diplomatic Relation. And I think they spoke as it's been a while since I read the judgment. They spoke at length about a state's obligation to protect an individual abroad, but that very much still will fall. If I am a Nigerian or a British citizen, that would not assist that your position would still not assist me though.
You cannot enter the shoes of the judges of our jurisdiction, which have said that there is this matter of not being under an allegiance to a foreign power or state is a matter of making sure that representatives, quite apart from having the divided loyalties, are not open to prosecution for acts that they did which might be deemed to be against the interests of that foreign power or state.
Someone brought to my attention today something in this constitution, and the more I walk my way through it, and the more people bring things, different ones of us read it and point out certain things, I wonder, and maybe you all may have a proper explanation. So I'll read it, right? And it has to do with section 96 under chapter 8, judicial provisions. And I want you all to go to 96.7. Because I'm reading 96.7 to say, nothing in this section shall confer jurisdiction on the High Court to hear or determine any such question as referred to in section 36 of the Constitution. And section 36 says, the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a representative. Is that a contradiction, or is it there's something that I am not seeing?
I think we have to first of all read the entire section to get the context of what is written at.
Well, I ask it so that I am hoping that my two brilliant brothers on here will read it and tell me if there's something there. You can't. I know you used to play cricket, but you can't vote for me.
has been contributed by.
So one is saying the High Court has jurisdiction, the other is saying the High Court does not have jurisdiction.
Well, the matter here has, to me, must relate to these matters set out here.
What do you mean set out here?
Set out in section 96.
And what does section? So what is set out in section 96?
I've not read it and read it at the moment. I mean, I don't know if I have the time to read it while I'm on the program here now as well. But what I know is that that is clearly said at section 36 that the High Court shall have jurisdiction to determine.
I know that.
Right.
It clearly,
exactly.
It clearly
so I'm familiar with that.
But doesn't it also clearly say here at section 96.7 that nothing in this section shall confer jurisdiction on the High Court to hear or determine any question as it referred to in section 36? Isn't that what it's saying there?
Well, what to my mind, I think that my friend will interpret it as is.
I don't want you to tell me what he would interpret it as. I want you to tell me what you interpret.
Your interpretation.
If you read it at first glance, Jomo, the redress clause of section 96.7 speaks about nothing. Section 7 confers nothing in this section shall confer jurisdiction on the High Court to hear or determine any such question as referred to in
section 36
of this Constitution. Now, upon a strict reading of section 36, the High Court shall have jurisdiction to hear and determine any questions and any question whether any person has been validly elected as a representative. I believe that some might emphasize heavily on validly elected. What does
some do what?
Validly elected, the interpretation of validly elected. How do we determine validly elected?
Right. I mean, this was only brought to me this afternoon, so I did not read the whole section and digest it, but I just want to bring it for you all.
That would be my approach to it.
Mr. Luke, is there something you want to say in relation to that?
Well, I'm trying to read it. If you give me a minute.
Now, Maxwell, the proposed law, don't you think it's based on your read of the law as it stands now? Don't you think that it's the government attempt to establish an insurance policy, boy, just in case we have this wrong?
Indeed, Jomo, of course. There's no doubt about it.
Well, and the interesting thing is, though, is that it might even help to insure them, but and it will just cause them to basically lose political capital. I don't really see the sense from a legal standpoint or from a political standpoint, but I'm not going to put myself in the position of having to make sense of their actions. It's just for me and for us to respond to the actions as we see fit when it is necessary to do so.
Yeah.
Anyway. But and like I say, I mean, I think there's emphasis. There's emphasis that if it was a case where you are changing the act for future purposes, then fine.
Yeah.
You know,
I'm with you on that.
What the problem is about the retroactive effect, and I don't think that they are going to prevail on that point, and it's ill-advised for the government to embark upon that course.
But I asked a question earlier that I can't recall getting an answer. Although I see my friend Gary Cummins speaking to it, whether with a live case before the court, if the court, in exercise of the broad discretion which a judge has, whether that judge could say, okay, this matters before me. You changed the law, but I'm gonna disregard that change and analyze the law as it was at the time when the petitions were filed. Is there any precedent for that any place? Because Gary Cummins, very knowledgeable brother, says if the law is changed, the court must or the court shall. I ain't sure we get it from. He didn't point me to any case, but he's a knowledgeable man, and I wouldn't disregard what he says. But I'm asking both of you on there, or anyone else in the audience, if they know of an instance where a court can exercise its discretion and disregard a law that is passed to quote unquote clarify what the law is or what the law should be.
Well, Jomo, I think it's based on the fact that you have many authorities which speak against, which speak to unfairness. And
with respect, you're not answering my question, though.
No, Jomo, I'm saying the authorities would say that it is unfair to pass a retroactive law.
No, but you're not answering my question.
I am answering your question.
No, you're not.
Okay.
So I want you to think about the question I'm asking and answer that question. Are there precedents for which a court can say, look, I know NDP, you passed this law. Let's not just say a court. Justice Tom, 27, 20, 28, 29, and 30th, she says, NDP, I know you passed this law on April 21st, but in my analysis of this case, and when I take the evidence and when I listen to all the attorneys, I am going to sit that law aside and analyze the case and come to a judicial understanding based on what obtained at the time the petitions were filed. So the question for me is what it is. If you know of any, if you don't know, you don't know.
I believe that Gary Cummins, as you say there, has a point, and time will tell in relation to
Why
this
you
case.
why do you think Gary has a point?
Because I've expressed the view that the proposed law is illegal.
Well, Gary's saying the opposite of what you're saying. Gary says the court has to deal with the laws that has passed.
Well, you said that Gary is saying that the court will disregard a
No,
retroactive.
no. The opposite. The opposite. If that's what
Oh,
you heard me say, I apologize.
oh,
But
well,
that's not what I said.
I heard you say something different.
Max Ron, you find anything? What are you doing?
Um,
You can ask AI and see
no,
what AI says.
no. What was that? I think I did do some research on this before. Um, and I remember a case coming out of, I can't remember if it's India, one of those places that spoke about amendments to the constitution when the court is seized of um of a matter. And what I think, and I'm subject to correction, and I will send the case as soon as I am to you, Sangha, and of course to you, Luke, um, is the court will only stay um when there appears to be when it offends the sense of justice. So what happened in the case of Attorney General, and I think it was Mitikala, it was emphasized that the court cannot disregard provisions of the Constitution, as doing so would lead to anarchy. However, there are exceptions, such as where there are specific constitutional provisions prohibiting amendment or certain articles or entrenched provisions that are subject to immutable principles. So, what the court in essence said is that if the procedure for the amendment is followed, then there is nothing that the court will do unless it will offend the court's sense of justice, because the court's duty is to this. So, in that regard, if it is that this particular is coming through the parliament in an illegal manner. So, for example, if there were delay provisions, I think they are called, and those delay provisions were followed, then there is scope for challenge. But if they aren't, then there is really no scope to that. I'm subject to correction, Jomo, because I'm
Yeah.
speaking ahead where that came
The
from.
other question I wondered about, and I raised it in my column last week. What is so significant that a prime minister, two of the highest ranking government ministers, a prime minister and a foreign minister, won an overwhelming majority in the parliament, and is hesitating to relinquish their Canadian
Jomo,
passport? Hold on a
Jomo,
second, sir.
if I may
Hold on a
answer,
second. Hold on
oh,
a
sorry.
second. Hold on a second. You want to answer the question I'm asking?
I want to answer the question that you asked about Section 96.
Oh, okay. Okay.
But you
Well,
just know
yes, take the opportunity to answer 96, and that's where it says that the High Court shall not have jurisdiction, right?
yeah, in respect of Section 96, what I think is happening here is saying that this section, as in Section 96, applies to breaches of the Constitution which are not found in Section 36.
And where you saw that?
This is so basically this talks about breaches of the Constitution apart from point one. At paragraph 6, it says the rights conferred on a person by this section to apply for a declaration and relief in respect of an alleged contravention of the Constitution shall be in addition to any other action in respect of the same matter that may be available to that person under any law. So the person could apply for relief for a constitutional breach under this section. But the last paragraph says, nothing in this section shall confer jurisdiction on the High Court to hear and determine any such question as is referred to in section 36 of the Constitution, because those questions are already dealt with in section 36. That is my understanding of what is set out here in section 96.
All right, Jomo, we have a caller.
Caller, good evening. It's time for your voice.
There were 5 different politicians from the Caribbean, all late, that were born somewhere else. Edward Seaga was born in Boston, Prime Minister of Jamaica. John Compton was born in Canouan, he was Prime Minister of St. Lucia. The late Assad Michael from Antigua, he was born in Guadeloupe. The late David Thompson, he was born in the UK. And there is one more. Oh, the late Jagan, she was the wife of Chaddy Jagan, Janet Jagan. She was born in Chicago, and she was the president of Guyana. So I don't know.
You make that point to make which one? You make that point to make which one?
Well,
it has to be. There has to be a larger point you want to make.
No, I want to know what's the rules in those countries that did allow those people to. Although they wasn't born in those countries. All right, that's all I gotta say. Bye.
Yeah, thank you. I don't know. I mean, I don't know what a Guyanese constitution say on that point.
Well, I mean, we don't know the specific rules, but I'm presuming that they would have satisfied the rules which existed. In the case of in the case of several of these persons, for instance, John Compton being born in the Grenadines, but he moved to St. Lucia. I'm sure he became a citizen of St. Lucia, one way or the other. And the question of whether or not he retained Vincentian citizenship is something that may be open to inquiry. But I am certain that they satisfy those conditions. But that will be a point for research, nonetheless. But it doesn't really elucidate the issues in this case because we don't know the particular facts. We could only surmise. What we do know, several instances of persons who had to give up dual citizenship in order to continue in their profession as representatives. So that point is clear, and that point is salient to us in light of our facts.
There was a question I was going to ask before. Now it kind of eluded me. Oh yes, what might be so significant in the Canadian citizenship? What do you all think? That both gentlemen, two high-standing officials in our government, Prime Minister and Foreign Affairs, seems to think quite unkindly of moving to give that up so that there can be no possible legal impediment to their legal occupation of the Parliament in St. Vincent and Grenadines.
Well, I don't know what there could be. What I would say is that I think that it amounts to a certain degree of recklessness and irresponsibility on their part. They may have thought that there is safety under the law. That position may have evaporated now based on recent actions. But to me, it's a bit of recklessness and irresponsibility and disregard for the trust of the electorate. I mean, I interpret it in those terms.
Distrust, but didn't the electorate know fully what these gentlemen held, and they still voted for them overwhelmingly? So how could you say what you just said?
Well, that didn't prove that doesn't cure the fact that their qualification is in question.
No. Come on.
No, don't, Jomo. I am saying that you have confidence of electoral victory. You take a constituency like the Northern Grenadines in its current condition. You have confidence that you are going to be elected. You are vying to become the prime minister of the country. I can't see what is
No. But the point,
so important
the
about
question I
holding on
was
to the
asking is that people knew that these gentlemen had carried Canadian citizenship. You and your party made heavyweight of the fact that they had Canadian citizenship. Not so?
Yes,
Right.
and if it
That's
and if
what
we,
you think it might be? You think it's just insurance?
Well, Jamal, not to speak on anyone's behalf, but what I can say is that there are multiple reasons why persons have dual citizenship. Sometimes greater global um access to social services, right to live and work.
We are talking here about two gentlemen in their 60s, and who probably will be in Parliament for another 10 years.
When you're 60, you still have your whole life ahead of you, Jomo. You
I
would
know. But if
you
you are
try to
leading,
comfort Jomo.
if you are leading, you better try to see if you can reach 50. If you are leading a government, we know, for example, that there's a practice here where prime ministers and former prime ministers can get health care, the best health care Vincentian taxpayers' money can buy. So what is the story about the social services and so on and so forth?
Yeah, as I said, people.
I think. Sorry, go ahead.
Go ahead, Lou. That's okay.
No, I was just saying that I think that they owed it to their constituents to be secure about their qualification to be candidates, and I think that is a commentary that cannot be ignored. They owed it to the constituents to be secure about their qualifications.
Yeah. What based on the you may recall when the court met for the first hearing, the attorney, look, is Mr. Stewart your attorney?
Stuart Young, yes.
Right, Stewart Young. He said, well, you know, we'll see how this plays out. The Vincentian Constitution has some interesting features in there. We will argue it, and then we will see how it plays out. If you are a betting man, how would you bet, Luke?
Well, I suppose the fact that I put myself in the position of bringing these petitions would give you an indication of what I think about the law, and that might have been clarified even further during the course of this conversation. I don't want to put myself in the position of making a determination for the court, but I believe that we have a strong case. I believe that we do not have a case that is frivolous at all, and we leave it up to the determination of the judge as to the merits of our case in the final analysis.
Maxwell?
Well, Jomo, I don't think that it is a frivolous case at all. I'm very much looking forward to the final decision of court. Of course, there's a serious issue to be tried, but of course, my position would be certainly not. My money would not be on Luke's position, because having read and studied this for some time, it appears very clear to me. So that would be my position.
It appears very clear to you. What?
He said, having read what he read, it appears very clear to him that the parliamentarians are going to survive.
So, what authority What authority have you read that gives you such clarity?
The Constitution.
Well, the that you rely on.
I mean,
Um, there is
I tell
rely.
you, we have a definition of foreign power in our state
But look,
in the law.
let me ask you this though, because this is not really a laughing matter, right? And I think I alluded to it at the beginning, and now that we are coming to the end, I want to ask you again. Assume for a moment that the court rules in your favor. And as I heard your leader saying, they're going to throw away the other votes, so you would assume the seat in parliament. Don't you think such an entrance into parliament would literally obliterate any chance at all that you may ever have again in contesting if you want to serve out a term in the ways in which you guys seem to be salivating?
Jomo, you think so?
Well, since you asked me, I'll tell you. I mean, if you want to go and serve in parliament, having lost by 1,001 votes, if you want to go and serve in parliament and the elections come up, whenever they come, you may lose by 2,000 votes.
Jomo, stop speaking in the language of hyperbole.
I said may. There's nothing
that is hyperbole. That is hyperbole. The truth is, Jomo, I don't concern myself about what may or may not play out in the future.
You don't concern yourself about what the people say?
I that's not what I said, Jomo. I said I'm not concerned about what may or may not play out in the future. I live in the moment and take one step at a time. I mean, my political future is not something that is just, and my future in general is not something that is in my hands alone. I have trusted faith throughout the course of my life, and I am prepared to trust faith again. And the fact is that we entered elections to be conducted according to some rules. And I'm saying that I am prepared to accept the outcome of those rules. I have not said that I want to enter parliament in one way or the other. I'm not commenting on what might be the implications of entering parliament in one way or another.
Just wanted the law to take its course.
Just let the law take its course. You know, I think that we have already very much illuminated this constitutional matter in such a way that I consider this to be almost a victory in and of itself, that we tested, we had the courage to put a lot on the line. You know,
no, but look.
Mm-hmm. To put a lot of resources.
You know that this is pure opportunism, right? Because you were in an administration before, and you didn't ask that it be challenged. You were in an administration 2015 to 2020, no, sir?
Yeah, well, I was in the administration.
It's pure opportunism. Don't tell us about courage.
Jomo, you, with all due respect, you're not at liberty to characterize my case in the way in terms that you see fit.
No, but I'm saying you are a parliamentarian.
Opportunism.
Tell us the truth. In the 5 years of cabinet sittings that you had in between
the Denzel Douglas
did that issue come up? Did the issue come up about challenging Friday? And well, Bramble wasn't there then. Did it come up with challenging Friday?
Did Denzel Douglas know? Well, first of all,
isn't it also
the
true?
Denzel Douglas case,
isn't it also true?
Which clarified the law, Jomo, was decided in 2020. Whatever happened before 2020 is irrelevant.
Relevant.
That is a case which provided the clarity, that provided a platform for proceeding with this petition case. And I'm simply saying that we decided to test the law. We have gotten to this point. There is a non-trivial case to answer. We are going to abide by the outcome of the court. We just want to proceed according to the rules. I think that is a fair position for us to take in relation to this matter.
I think so too.
So so this is at this stage in respect of
Let me ask this question. And both of you can answer because I don't want Luke to think that I'm directing my questions at him.
You might be.
How do you come down on the view of Dr. Gonzalez, where he's now and you are now insisting that look, let the court decide this, whereas a short little while ago you all were saying judges shouldn't decide these things. Judges shouldn't say how people should vote.
Jomo, this is to me. First of all, the judges are not deciding the cases. The judges are deciding if the elections were held according to the rules and they're exercising their duty.
No. The broad view is that courthouse don't determine any of this.
And that is a right view.
That is our system. Judges do not decide who your representatives are.
Under the Constitution, the judge decides the qualification or disqualification of candidates. So that is what the judge is deciding, whether or not a candidate is qualified or disqualified.
So once the judge does that, isn't that a determination as to who the representative is?
It is a determination as to who is qualified and who is not qualified. And as a matter
once the judge makes the determination who is qualified and who is disqualified, isn't that a determination as to who the representative is?
Well, a determination as to who the representative is will be made on the basis of that determination.
Luke, but don't do that to yourself because you're not doing it to anybody. Don't do that to yourself.
Jomo, it's not a case of first of all, it's not a case I maintain.
We are coming to the end. So
before we go to Maxwell, if you may just permit me, it is not a case where the judges are determining the case, who wins. The judges are determining who is qualified and disqualified under the law. And moreover, I want to make this additional point that K Bacchus, for instance, after the first hearing in this case on the 5th of March, she was making that argument saying, oh yes, the courts don't decide election cases, they are decided at the polls, and this is the same person who in 2016 was hung in Sir Louis Straker because she believed he was not qualified to be a candidate.
Did you remember?
If the shoe was on the other foot,
do you remember how my column ended? My column ended saying, you're talking about people like, singing a different tune. And then I said, politics, narrow, partisan politics is ruling this nation. A refusal to be duped by either side of the political divide is the surest guarantor for our maturity and development as a people and nation.
Right, true. And we also have to refuse to be duped by you, Jomo too. So it's not just a matter of politics.
Let Maxwell speak.
We are going on it, really?
Huh?
Yeah, I think we're at the end.
We have a minute and 54 seconds.
What?
Luke want to lock you out, Maxwell, but I would not let it happen.
No. I just responding to you, Jomo. I don't want to be duped by you either.
No, I wouldn't attempt to dupe anybody.
How you think?
What I'm saying is that as much as my friend would not like to admit it, the spin-off effect is the same. And if we have to speak of democracy, and I think persons spoke about it, spoke about democracy, and from the reading from the articles published, I think also we have to appreciate that the outcome of let's say for example, and succeed, then the same argument on democracy that others regarding this particular amendment tomorrow saying that, oh, we should do it by a referendum. That is the democratic way. We must also speak about democracy in the context of my friend's petition, because at the end of the day, it comes down to the will.
Just one short response
I
to
want
that.
to thank both of you very much for participating in tonight's program. You were good advocates, and I wish that those persons who came online or those persons who had a chance to listen on the radio really had a chance to ventilate to hear you all ventilate the issues and to come up with a better understanding of what are the matters before us here in St. Vincent and the Grenadines, the issues that the court would decide when Justice Tom presides on the 28th, 29th, and 30th. And we all wait with bated breath to see what the result is going to be. Evidently, I disagree with Prime Minister Friday. This is not a frivolous matter. The proposed amendment is evidence that he does not think it's a frivolous matter. And we will see what happens. The case ends, the actual evidence taken ends in July. Then I'm sure Justice Thomas is going to take a little while before she comes back with a decision. But certainly, before the end of the year, I think we're going to have a decision. And you can be certain both sides, the losing side is going to appeal. So we may have to wait just a little longer, because that's what happened in Dominica when not Dominica, in St. Kitts, Justice of Appeal Trevor Ward ruled that Denzel Douglas had not violated any law, and then the matter went up, and Justice Pereira, leading the writing the decision for the court, felt yes, he did violate. So thank you all for coming.
Tom was also a member of the panel.
Excuse me?
Where Justice Tom was also a member of the panel.
Yes.
And Jomo, just to say that in a final word, democracy is about free and fair elections, and fairness is about playing by the rules and not permitting the possibility of retroactive legislation.
Yeah. All right. People remember to read. Pay close attention. There are so many things that you could have done. You stayed with us for all this time. I want to say good night. We see you again next week with another exciting, informative, inspirational program. Thank you.
WeFM 99.9 presents Voices, a talk show that's not just new, it's phenomenal. Voices.